Mr. Chairman, you're live.
Meeting to order whether we have a quorum or not. All right. So,
We got time.
all
We gotta get
right.
things done.
Welcome everybody to another what probably may not feel as early to you as it does to us, but definitely feels early to us. But with the snowy drive in this morning, thank you all for being here, and let's go ahead and call roll.
This is roll call for House Revenue, February 19, 2026. Representative Brown,
Here.
Representative Campbell, Representative Lean,
Excused.
Representative Lucas,
Excused.
Representative Riggins,
Here.
Representative Storr,
Excused.
Representative Stiver,
Present.
Representative Worf,
Here.
Chairman Locke.
Present.
Mr. Chairman, you have a quorum.
All right. Very good. Excuse me. Sorry, I might have a little bit of a problem there. Looks like maybe the reader of the bill we're going to start off today. Well, let me start off just again, thanking everybody for coming. And I really do appreciate everybody coming here today. I know I bounced everybody around a little bit. Those of you who felt like you'd been bounced around like a BB in a box car trying to get through these bills, I apologize for all of that. And thank you for your patience in working with us. And we're basically going to go over three bills today. House Bill 109, property tax exemption application date. House Bill 62, the Christian Smith Safety Act. Now, this bill, we finished public comment. So that one is a bill we're just going to, the committee's going to make a decision whether they're going to work it or not. And then House Bill number 101, guardianship protections, is going to kind of be the order today. Just want everybody to be aware of that. That being said, Representative Lean, since we do not have the bringer of the bill, and as it turns out, looks like you are on it. Are you willing to bring the bill for us?
Yeah.
All right, very good. Let's go see that. We improvise, we adapt, we overcome. That's the rule here today. So, okay, great.
The Air Force can do that.
Very good. So Representative Lane, thank you so much. We are on House Bill 109, property tax exemption application date.
Thank you, Mr. Chairman. Thank you, committee. This will not be as eloquent as the good representative that drafted the bill, but I shall tell you that this bill currently asks to move the date for the 25% to be the second Monday in May. You'll see that there is a pending amendment that we're asking for, and it is to move it to the 1st of March to maybe add some uniformity to the deadlines within the assessor's office for tax exemptions. That's the need of the bill.
Questions? So, Representative Lane, I would like clarification. So right now, does the amendment that you're asking, it would take it to March next year, is that correct?
Yes,
That the
Mr. Chairman.
Intent of the exemption. So this bill moves it to the second Monday of May this year, but then would move it to the March 1st date, 27.
Yes.
Is the intent of the amendment.
Yes, beginning in 2027 and in perpetuity, therefore moving forward.
Okay,
The anticipation behind the amendment is that there already is the March 1st deadline this year, and therefore people will already be anticipating to have it done March 1st moving forward.
okay. So maybe it would be good to explain a little bit what the intent of the bill was overall, because I know there was I think currently this year, March 1st is the deadline. And if you can please maybe explain what kind of the intent was with the bill, that'd be great. That way everybody can be aware of what we're doing here and what makes sense.
Mr. Chairman, this bill in front of us moved it to the second Monday in May, as the rules that were drafted through the Department of Revenue ended this February 1st, and then there was an extension to March 1st. And so this would have given the assessors the opportunity that when the tax assessments went out the end of April, if somebody was angry about their tax bill, they could say, here's this paper. If you live here 8 months of the year and would like a 25% reduction, that would pacify them. So that was the intent of having it March or May, the second Monday in May. And then that still allowed for the assessors to have a few weeks of buffer zone to put out their June obligations to the State Board of Equalization.
Thank you. Anybody else with questions, please feel free to jump in. Let me propose that one of the things that I do know is going on, and I think I at least want to make sure this is being stated out there, is that I know it's tricky. We're kind of going through a transition. This 25% last year was, it was for everybody. Nobody had to apply. And I think one of the tricky situations we're seeing is with applying for the affidavit, which absolutely is what has to happen. And thank you to the department, by the way, and the assessors for all the work that they've done, because they have actually worked very hard on this. But I think one of the things that might truly be the case here is that I think we're all worried that many people who theoretically qualify may not getting signed up, if you will. And so I think that is an element of this too, but that's me thinking out loud. And I guess maybe I should ask that a question. Would you agree with that, Representative Lee?
Yes, Mr. Chairman, thank you. And the prime sponsor of the bill is here, and I'd like to turn the time over to her.
Okay. All right. All right. So Representative Bratton, thank you for coming. Any questions? Representative Lean delivered the bill. Please feel free to jump in and say anything about the bill you would like to say, please.
Thank you, Mr. Chairman. Apologize for being a little tardy this morning. And thank you, Representative Lee, for starting off and presenting the bill. So do you want me to go ahead and reintroduce it, or is everybody good on what the bill does?
Well, if you'd like
The bill?
to go over it real quick, please, that'd be great, but probably not too much. Representative Lee went through it, and it's not that long a bill, so we won't beat it up too bad or beat the room up too bad.
All right. Thank you, Mr. Chairman. So I'm sure she said that the legislature enacted the 25% property tax exemption for the owner occupied homes, and and that was applied automatically. But this year that changes. The homeowners must now go online and affirm they live in their home at least 8 months out of the year. The first direct notice that homeowners will receive that their taxes are increasing for many of them will be when those assessments are actually mailed out in late April. And by then it'll be too late and the deadline will already have passed. This bill makes a narrow targeted fix, and it moves the deadline to the second Monday in May, which allows homeowners a brief window after receiving their assessment notice to sign up. This doesn't expand the exemption, doesn't change eligibility. It doesn't increase cost, and my county assessors have confirmed it's a manageable time to allow them to meet their June reporting requirements for the Board of Equalization. That's a June 1st. So this bill simply prevents thousands of Wyoming homeowners from being blindsided by a property tax increase that many have no idea is coming. And I do want to say that so many, our assessor's offices, they have sent out, I think they've really done everything they can. A lot of you've seen it in the papers, but I'm continually surprised that, people just don't realize that at least this first year that this is coming. So at the request of the Congress, the Converse County assessor and some other assessors, that's why there's an amendment that I think you all have to make this a one-time fix, because I think after this year it's going to be kind of a big surprise for some people, but after this year, they've asked that we move it back to the March 1st deadline, where a lot of other people I think there's some other bills that are assessors issues that are being moved back to that March 1st deadline. So that'll make it easier for them. And with that, I'll stand for any questions.
Very good. Any questions for Representative Bratton? All right, you're getting off the hook very easy. Thank you so much and
Thanks.
welcome to the Revenue Committee. I don't think we've had a chance to have you before us yet before. So thank you so much. All right, let's move on to the department probably, or department and or assessors, whichever you would like. It's gonna go fast, I think, but go ahead. Yes, please. So whoever would like to start would be great.
Good morning, Mr. Chairman, members of the committee.
Thank
Dixie
you, Ms.
Huxtable,
Huxtable.
Converse County Assessor, and here with some other assessors in the room. So if anybody has questions, we can certainly ask for their help on some of this. This bill is administrable. I'd like to lay a little bit more groundwork. So when this got passed a couple years ago, we knew this was coming. So we put it on their tax bill. So every taxpayer last year in the state of Wyoming on their tax bill got a notice that this was coming and that there was a long-term homeowners with a deadline. We even put the portal, we worked with the Department of Revenue to make sure that was all set up and working before the tax bills even went out. So we've done a lot to make sure that the taxpayer knew about it. Unfortunately, I can't help them read their tax bill. So they've had notice. We've sent out flyers, we've had town halls, as Representative Bratton had spoke. We've done about as much as we can do, and I know that several legislators have sent out postcards reminding everybody. So there's been a lot of talk out there. For 1 year, I certainly understand why the need is there to maybe extend this to the second Monday of March, or in May, excuse me. We can administer that. It will be a little bit of a crunch time because as she said, people get their tax bill or their tax notice, excuse me. And if they don't see that exemption, which we have worked really hard with the Department of Revenue to make sure it's all transparent and on the notice of value along with the tax bill, they will still have an opportunity to come in and get that added. The reason we ask for the change back to March 1st is when there's another exemption that's going to March 1st. That gives us the opportunity to put it on the notice of assessment. They can see it. It's transparent. We just feel like that's the best way to keep everybody informed of what's going. So can we do it this year? Yes, we can. We're used to a few changes. You should see our calendar and it just keeps getting new deadline dates all the time. We really like to keep that pretty consistent for the taxpayers because most of us have that posted for our taxpayers so they know what the deadlines are. And adding one more date just kind of complicates that calendar. But if it's only for 1 year, I have a erase board. I have a dry erase board. I can get rid of that for next year. So with that, we would stand for any questions.
Thank you, Ms. Huxtable, and questions for Ms. Huxtable? And thank you for going through that. I know it has been actually our goal to work with you guys to get the timelines a little tighter and maybe more consistent. I appreciate this bill from the perspective that with this first year, I think is where we're seeing a little bit of the chaos. I happen to be one of those people that sent out postcards, and I'm still shocked at how many people said, geez, we didn't know that after all of the notices that you guys have done. So thank you for being so diligent.
Mr. Chairman.
And so I can totally appreciate, you can't make them read the information, can you? So-
And unfortunately, just Mr. Chairman, in my county, they just got them in the last week. And so unfortunately, a lot of them thought it was a new one. Whatever the verbiage was on that postcard, they felt like it was a new exemption. So over half of the people that came in that first week had already signed up. And so then we had to explain, no, it's not new. This is something that was in the law. So it really does confuse them when we start sending stuff out, especially with different dates, because they do think it's something new. So we'll work through it.
Thank you so much. And thank you for working with everyone too, because I think that this will hopefully get us over the gap a little bit and then we can get on a cleaner glide path. But at the end of the day, I know that all of these dates are tough when it's tough on you guys on the reporting side. We do know that. And so it's tricky, but thank you. Mr. Gill, please.
Mr. Chairman, Ken Gill with Department of Revenue, Property Tax Division Administrator. Yeah, we can administer this bill. We've provided the portal where folks can notify that they occupy the property that they own. We'll be able to extend that out and still accept those applications. One nice thing about our portal, I should mention, we did all the programming in-house, and it is actually tied into the statewide camera system. So as as we go forward, we've gathered this information on owner occupied. I'm not sure what the future looks like, how we're going to deal with tax year 27, tax year 28. Not really sure how we're going to do that yet, but we do know that if ownership changes, right, probably a new owner, now they occupy the home, they're going to need to apply in the future. So we can do that in the system. We know when ownership has changed, and we can drop that old owner off of the list and put the new owner on when they apply. So we'll be able to extend it to the second Monday in May. Everything is date stamped in this system. So when you send in that notification, it gets a date stamp. And so we'll know which ones to download to the camera system should it be after the March 1st date that's current.
Very good. Thank you. So much questions. Representative Lee.
Thank you, Mr. Chairman. Thank you for coming today. My question is about doing this in rule versus statute. Is there a benefit to the department to have it one way or the other?
Mr. Gill, please.
Mr. Chairman, in statute, Representative Lean would be great to have a date in statute, I believe, but we can always do it by rule. So by rule, it probably is a little easier to change if we need to than going through changing a date in statute. But you know, either way, Representative Lean, we can do it.
Thank you, Mr. Gill. And I did want to say thank you for the process that you guys put in place. I found it super easy to use, at least, so I'm just speaking for myself. Super easy to use, went right straight there, signed up. I will apologize for the fact that I know that we have a mix of people. We have the long-term homeowners and the 25%. So I'm the guy who took the shotgun approach to say, sign up for everything. So anyway, but that being said, so you might have a little bit of that craziness. But anyway, hopefully your systems are set up for that. Other questions for either Ms. Huxtable or Mr. Gill?
Mr. Chairman, if I could.
Please, sir.
Currently, we have around 47,000 on the site that have notified the assessor that they occupy their property. So 47,000, we had about 35,000 long-term homeowners last year that applied. So we're getting closer to that number that we think is probably around 110, 120,000. So we're getting closer.
So that's your estimate for both categories. You think that 110, 120 is closer to both those two categories?
Mr. Chairman, yes, I think it'll be pretty close when we look at the numbers from the census and from the Economic Analysis Division. Somewhere around that 120, I think, will be about the sweet spot. Of course, we will have some folks that don't want to apply. We've heard from those folks that they don't want to apply. And if you remember the former Senate File 69, it gave that carve out that if they didn't want the exemption, they didn't have to take it and they could ask for it to be removed.
Absolutely. Okay, thank you. That's actually helpful. And we probably do need to kind of sort of keep track of that number moving forward. This body definitely needs to, because that's something we have obviously have to wire into the revenue streams and how it's impacting us. So that's very good. Thank you. And I know you've always estimated this, but now you're actually getting a little closer to where you can feel a little bit better about that number. So thank you. Excellent. Any other questions? And thank you so much for being here. That's fantastic. So anyone else who wants to speak on this bill in the room, and I think we have no one online, right? So please. Mr. Ryman, thank you for being here today, and please proceed, sir.
Good morning, Mr. Chairman, members of the committee. I wanted to get up here because if you look at our bill sheet, it says we oppose this bill. Really appreciate the good work of the representative, and with the amendment adopted, we would actually support the bill. So very happy for you to move that forward. And I do want to say that this is current tax policy. And although we weren't too excited about the 25% reduction, we've even ourselves taken to our social media and other channels to try and advertise, to tell people that this deadline is coming up. So we're trying to be a part of that solution for people for this year, and we'll certainly do that in the future. So with that, Mr. Chairman, I'd stand for any questions.
Thank you. And Mr. Ryman, thank you for that. I really appreciate the folks out there doing that. It's helpful for us to get this on a level flight plan, right? So thank you. Other questions for Mr. Ryman, please? Thank you so much for being here, and I'm sure we'll talk about many more bills before the session's even over. All right, anyone else to speak on this bill? All right, so this is where I have to remember, public, anybody, we're opening public comment to anyone in the room, anyone online, and seeing none, I am closing public comment. Committee, what is your pleasure on the bill? Mr. Representative Brown has moved it, seconded by Representative Campbell. All right, so let's work the bill. Yes, sir.
I would, move the amendment if we could discuss that.
All right, so the amendment has been moved. It has been seconded by Representative Lean and Wharf and half the people on that end of the table. And so so let's discussion of the amendment. Any discussion on the amendment?
I'm in favor of it.
Very good. No, seeing no discussion. All in favor of the amendment, say aye.
Aye.
Opposed? Okay, very good. Other amendments. I'm not gonna go page by page. It's short enough. We should make it simple on ourselves. Seeing none, moving to the bill, discussion on the bill. Oh, yes, Representative Lean.
Mr. Chairman, while we have this bill in front of us, I'm curious about the 8-month requirement, and does this need verbiage to help this exemption follow the individual?
Mr. Gill, that's a good question. Do you mind, or even Ms. Huxtable? That is absolutely a great question, because that was a conversation that we've had, and I'm sorry we did not have that. So.
Yeah.
Ms. Huxtable, your opinion on that is, and you recall, I think that this question is actually coming because we had this conversation on the long-term homeowner. And the question is, do we have the same issue here? Ms. Huxtable.
No, thank you. Mr. Chairman, Representative Lean, we do have a similar issue with the long-term homeowners because the language initially was the same in that it was an eight-month occupancy residency. I do believe that most of the assessors, or all the assessors, as we had a meeting this week, talked about administering them both the same, even though they may not be spelled out clearly in statute, that because House Bill 45 is going through with that alternate language in it that allows the months that you reside in the house that you sell to be added to the months of the house that you purchase to qualify you, that we'd be administering both of these bills for consistency's sake the same, both of those exemptions. However, if it was in statute, it would certainly be clearer. Just because then it would be in black and white in the green books. But we will be administering them the same, presuming that that bill makes it all the way through, that that 8-month does include both the months that you had in your old house and your new house. It's not the perfect answer. It was what we came up with that day
Okay.
here. It doesn't solve any of the issue with prorating the taxes when you buy and sell a home. That's something that's not covered, but
Right.
it certainly does clarify it for us that you're going to count those months in those two houses. So if it was to be added to this bill, we would support that, and it would be helpful to have it clear, but we still will administer both of them the same way, I believe.
Okay, thank you. And Representative Lane, please go ahead.
I was just gonna move an amendment, so you could please finish your thought.
Okay, I was going to just ask, and Mr. Gill, sorry, I don't, but I am going to ask you this question. Is this something that the only issue I want to make sure of, and we will probably amend this bill. I just want to make sure we can amend this bill. With the title, make sure we have it's appropriate if we decide to do that. But if not, Mr. Gill, do you believe this is something that you can handle in rules? Is that an acceptable process for this? I just wanted to get your thoughts on that, sir.
Mr. Chairman, in rules, possibly, but the way the bill is currently written, it's not really clear that it's 8 months in the future or 8 months in the past. So I think it could be interpreted both ways. So I think with that language in statute would probably be better. And the language that Assessor Huxtable came up with during the long-term homeowners testimony, it would probably satisfy it. The only question I would ask is the title of the bill is application date. Would that amendment be outside of the title of the bill? I'm not a lawmaker, but.
That's a good question, and I think that will be a conversation we'll have to have, but thank you. I appreciate that. Okay, fair enough, and thank you for kind of some of the clarification. Appreciate your time there. So let's go ahead, Representative Lean. I know you have an input on this.
Thank you, Mr. Chairman. I move. Apologize, I flipped screens. On page 2, okay, so let's do page 1. On the title of the bill, strike application date and just make it say amendments. And on page 2, line 15, after the word year, insert if a primary residence is sold and another primary is purchased within the state of Wyoming, the months residing in both owner-occupied residence shall apply to the requirements of this exemption.
Mr. Chairman, would the bringer of the amendment either be able to give me a copy and or repeat it?
Mr. Chairman, I'll email it to him real quick.
Thank you.
Perfect, perfect. Now
Second that.
okay, so that amendment has been made and seconded, and Ella, so just keeping us in line, are those changes acceptable? Are we within our appropriate boundaries there?
Mr. Chairman, we would have to consult with legal. We couldn't be able to make a.
Oh,
that
okay, very
determination.
good. We'll keep that in mind as we move forward. So this bill or this amendment has been moved and seconded. Any discussion on the amendment? Representative Lane, any question?
Thank you, Mr. Chairman. This is the exact verbiage that went into the long-term homeowners, giving us clarity and giving the ability for the assessors and the Department of Revenue to implement this for all Wyoming residents.
Okay, very good. So we'll, any other discussion? All in favor of this amendment, say aye. Aye. Opposed? All right. So the bill has been amended. Any other amendments, or are we ready to vote? All right, question being called. Let's call the roll on this bill and move it forward.
This is a roll call vote for House Bill 109 as amended. Representative Brown,
Aye.
Representative Campbell, Representative Lean, Representative Lucas, Representative Riggins.
Aye.
Representative Storer. Was an aye. Vice Chair Stivar,
Aye.
Representative Worf,
Aye.
Chairman Locke.
Aye.
Mr. Chairman, you have 9 ayes.
All right. So we're gonna move on to House Bill 62, and I think the way this ended was we had actually closed, thank you, Representative Bratton, for being here today with us. So moving on to House Bill 62, that's the Christian Smith Safety Act. We had heard public testimony on this one. And we'd closed public testimony, but I think the committee had agreed to lay this back for a day. So I'm going to ask, since we voted on laying it back, do we want to work, what's your pleasure on the bill? Let's just make a decision. Representative Worf.
Mr. Chairman, I just want the committee to know, since our last meeting, I have been able to visit somewhat with Mr. Racines. We weren't able to meet with the Trial Lawyers Association yet, but in consultation with him, I know I had told you guys I would try to get some information. I'm still looking at, possibly bringing an amendment. I don't know that it could be done this year. I think it's going to be, we're on the fast track, get things done, and I don't know it can be amended, but I still think it's problematic. And so I'll probably be a no vote on the bill because I think it needs to be amended. I would like to see it, probably a 3-tiered system. Those that, and I guess I'm not going to prejudice my opinion. We'll go collect the data and see what it says. But I believe that working together, we can reduce the cost and allow that the citizens of the state are protected, but also allow the risk that the state has to take with insurance, that it can be somewhat mitigated and minimized to the best of our abilities. So I'm going to ask that this be an interim topic. I'm not going to say hold up the bill for that. I'll be a no vote because I don't think it's quite ready yet. But if, Mr. Chairman, if you would remind us that that's something I would like to explore on the interim, looking at a tiered system for claims.
And Representative Worf, whether, depending on what happens with this bill, if you don't mind making sure that makes our list, committee, so let's make sure that makes the list. That being said, we have not theoretically moved the bill yet, so Representative Campbell.
Mr. Chairman, I think this has got way too much on it and we do need to address it. And with that in mind, I'd make motion to table this to the interim.
All right, I don't believe that's a debatable motion. All right, so we're actually going to call roll on that. So let's go ahead.
This is a roll call vote to table House Bill 62. Representative Brown,
No.
Representative Campbell.
Aye.
Representative Lean,
No.
Representative Lucas, Representative Riggins,
No.
Representative Storer,
No.
Vice Chair Stivar,
No.
Representative Worf,
Aye.
Chairman Locke.
No.
Mr.
All
Chairman,
right.
that is 6 no's on tabling.
Okay. So is there a motion on the bill? Move the bill. All right, the bill's been moved by Representative, Vice Chair Stivar. Is there a second? All right, Representative Storer, thank you. Okay, so let's work the bill. This one, we'll just ease our way through it. Page 1, any changes, any amendments? Page 2, any amendments? Representative Lean, please.
Thank you, Mr. Chairman. On page 2, line 5, I'd like to strike 1 million and make it 375,000. And page, same page, line 16, strike 2 million and insert 500,000. Oh, let's do 750,000, sorry. 750,000.
All right. So 1 million goes to 375, 2 million goes to
750,000.
okay. All right, so that's the amendment. Is there a second? Representative Riggins. The seconded that amendment. Discussion on the amendment. Representative Lane.
Thank you, Mr. Chairman. After doing a little bit of reading from the reports that were given from when this was an interim topic, these were the amounts that were recommended. And I believe that we should start there, particularly because this has an escalator in it and it gives our self-insurance pools the opportunity to evaluate and see how this impacts them.
Okay, other discussion on the bill? Representative Riggins.
Thank you, Mr. Chairman. My biggest concern is giving time for these entities to come up with what their expense is going to be should this get passed, whatever they are. That's my biggest concern. And so I may be a no on this bill just because that's going to take time. So, thank you, Mr. Chairman.
Representative Brown, please.
Thank you, Mr. Chairman. Well, we see that this cannot happen or help the people that brought this bill. There are real problems with some of our citizens. They get injured like that, and they can't afford to take care of their medical bills and to be able to go forward, and it can destroy their whole family. I think we need to move the bill forward. We need more work on it, yes, but I think we need to move it forward so we can help people now and see what we can do in the future.
Thank you, Representative Brown. Others, Representative Ward.
Mr. Chairman, I too, I think this is a good amendment, an attempt to try to kind of tap it down a little bit. But I know not all claims are equal, and that's the concern that I have, is I don't want to set the cap too low, nor do I want to set it too high. And in reflecting on this, Mr. Chairman, I'm willing to change from a no to an aye. Just to let the body as a whole discuss this, because I think it is important, but I hope that the committee will think about picking this up in the event it doesn't pass. I don't want to lose it. Let's pick it up for the interim and see how we can frame it. But I will switch my vote from no to aye, just to let the body, committee of the whole, have a chance to look at this bill and talk about it.
Thank you, Representative Worf. Representative Stivar.
Yes, on Representative Lean's amendment, did she also want to put it on, or I missed it, line 18 and line 21 on page 3?
Friendly amendment to the amendment, Chairman.
Great, okay, friendly amendment. Who was the second? Who was your second? Representative Lean. Oh, is that a friendly amendment for you, sir? Okay, so did you guys catch that? That was a friendly amendment to the amendment. Okay. Guys okay with that?
I apologize, Mr. Chairman. The amendment to the amendment was, I do have the changing line 5 to 375,000 as
Okay.
well as 16 to 750,000.
So this amendment, yes. So this amendment would be on page 3, lines 18 and 21. And those numbers there would correspond directly to those. Does that make sense? Very good. Okay, so we've adjusted that amendment. Conversation, any other conversation on this amendment? Seeing none. All in favor of the amendment, say aye.
Aye.
Opposed?
No.
Okay. All right. Any other amendments?
Mr. Chairman, just for confirmation, that did pass.
Yes.
Okay.
Sorry. The ayes have it. My bad. Any other amendments, changes to this bill? Seeing none, further discussion on the bill?
Question.
All right. So question being called, please take roll.
This is a roll call vote for House Bill 62 as amended. Representative Brown,
Aye.
Representative Campbell. Aye. Representative Lean,
No.
Representative Lucas. Representative Riggins,
No.
Representative Storer, Vice Chair Starver,
Aye.
Representative Worf,
Aye.
Chairman Locke.
Aye.
Mr. Chairman, that is 7 ayes, 2 noes.
Very good. So House Bill 62 has been passed. It will be moving to Committee of the Whole. All right. Moving on to House Bill 101, guardianship protections, and Vice Chair Stivar. Very good.
Morning, committee, Representative Stiver. I bring you House Bill 101 Guardianship Protections. Before we get into the bill, I'd like to give you some background. From 93 to 98, we had an Office of Public Guardian in the state of Wyoming. 98, things sunsetted. And when they sunsetted, some of the protections for were left off moving forward. I've had over this, well, since I've been in the legislature, I've had calls on and off about guardianships. This year, I had one of my constituents that get a hold of me, and I really looked into this. The bill draft you see in front of you is Bill Draft 11. It's very interesting to see what's going on out there. So I'll get into the bill. What this bill does is puts some of the protections back in. I don't know where's that at now. Still tired from last night.
That can't be. Come on, we've only had 2 almost all-nighters, so it's all good. Prepare for 3, by the way,
Yeah.
tonight.
4. No cost shall or fees be allowed in the amount that would unnecessarily diminish the ward's estate or to substantially endanger the ward's financial independence. You know, that was left out of the new statutes. I've got moved that one over. I also have an amendment to this bill, if y'all can get the amendment and we can go over it. This is an important amendment. Like I said, this is draft 11. And you know, I had it put in the bill of they must make monthly contact. That after being here in session, talking with a few folks in the audience, that was a had call. You've got guardians that are out of state, out of county. Like the weather today, they couldn't make it to see their ward. So they need to put it in, and that would be on line, page 1, line 2. Delete the monthly person contact and insert specified in person, line, page 1, line 4, delete in person. Line 2, page 14, delete in person and contact and insert in a reasonable form. Reasonable form could be Zoom, telephone, something like that. And the other one is, I've also put in here that once somebody is appointed as guardian, they need to go and notify their ward's payee. If it's Social Security, if it's railroad retirement, DFAS, whoever, because each agency has their own rules for how much they can actually take out of their pay to be the guardian. Social Security is 10%. I think the VA is around 15, but each one has their own information on that. So that's the deletion on which. That'd be, page 3, line 8, where it has, where's that at? The USC 42405J 4A, that will be restriction. That's social security guidelines. So, but this is a real big issue and we need to do something about it. So
Questions
I
for
stand for questions.
Representative Stivar, because, okay, so I have, I have a lot of questions since sort of new territory for me here, so
Oh, it's
bear with me.
everything that's in this committee.
So in short, the problem you're trying to solve, is this a reporting and a reporting problem that you're trying to solve with this guardianship? This looks like this puts some additional, maybe either providing, in some cases, almost looks like maybe flexibility, but by the same token, trying to ensure this this reporting and it's trying to add reporting. I think it was what it looks like.
It's
To make
adding
sure that
reporting.
it's happening, to make sure that people in these guardianships are properly reporting through the chains that they're supposed to. Is that accurate? Sorry. that
Yes,
was a
and
long
it's to
question.
take care of the ward's assets. All right,
Okay.
you know, you have one group that's doing pool trusts, you've got another group doing stable accounts. Because once, how do I want to put this? Pool trusts, they can't pull the money back out. So if I have guardianship over my son, he has developmental disabilities. So if I pass and give him $20,000, that will knock him out of resources. So he can't stay on the waiver, or he would not get his social security disability. He blows through that, you know, that would not sustain him throughout the rest of his life. So in 2015, they went to what they call a stable account. So that money could be put in the stable account, used for him, for his needs, hospital stays, pays bills, whatever. And there's a different here. We need to protect these wards' assets. And that's one reason I've said they have to contact the payee for that ward. If it's social security, railroad retirement, DFAS, military retirement, you know, a 401k. So it's out there because each agency has their own requirements. I pulled, and it was a little heavy-handed, and put it in by social security standards. You know, during the intern, like I said, I got calls from all over the state from different agencies, different constituents of everybody's that, you know, that they have problems with their guardianship and the way they're being treated. This is a big issue. You know, like I said, the guardianship statutes haven't been touched in 30 years.
Okay.
They actually need to be looked at and updated. You know, who says what a reasonable fee is? You know, I know what my reasonable fee is as a guardian myself. In the guardianship paperwork, it says I could charge reasonable fees and court costs. I'm my son's guardian. I'm my daughter's guardian. I've got guardianship over 2 of my kids. One with a developmental disability, one with MS on the on stage of dementia. I don't charge them anything. Every 6 months, I pay my attorney to submit my paperwork to the court to keep the guardianship going. I have to report to the court their financial expenditures. I am not their payee. I've had another agency, their group home, actually be their payee, so that their social security disability and their social security go to them, and they break it out in a ledger and says, you know, they made this much, this was the deposit of this much. You know, they're both in HUD housing, so it's, you know, this is the cost of the housing, this cost room and board on down, and this is how much they get. You know, I had one constituent with a traumatic brain injury called me and is telling me he's only getting $400 a month. And it's like, okay, and it's $200 every 2 weeks. but he's also got Social Security disability and state disability retirement. That adds up to more than $400. You know, and that's the question, why is this individual being treated like this? You know, an agency that charges $90 for a phone call or $22.50 for a missed phone call. I have a problem with that. That's why this is a bigger issue than just this. So this is just a quick fix to try to get this going.
Okay, so this brings, so this brings you're trying to bring some consistency to what the guardians can and cannot do, require some reporting to make sure that, I guess, to make sure that the ward's being cared for and being dealt with fairly. Is that basically
correct.
is the summary of this? And and have you basically put limits to how much they pay? Going back to some of those things, I don't necessarily see those, but I know you're pointing to several statutes that.
Yeah, but, and that's what I'm trying to, like I said, this is draft 11. And I was heavy handed when I put, what was it, USC 42?
Yes.
405 in?
USC 405, I think.
Yeah, that's the Social Security standard. I mean,
Okay.
that's heavy handed. I've, like I said, I've talked with, during the session, that's why I brought this amendment. Because, you know, who decides what a reasonable cost is? You know, 6-minute increments, how did that read? They can charge it for 6-minute increments for an hour, $275. And I know there's an attorney back here that can explain that a lot better than me. I went and had a conversation with Representative Lawley.
Okay.
And she needs to beat it in my head because she explained that to me. But in her practice, she does 15-minute increments. But she's saying 6 minutes easier to track than 15. Like I said, this is, but you know, does the legislator need to go in there and say, this is reasonable costs? I don't know. Or is that the judiciary branch? The district judges say this is reasonable. But, you know, the guardianship, the original guardianship corporation, or not corporation, Wyoming, Office of Wyoming Public Guardian was actually put in 83 to take care of the indigent in here, or in people coming out of the state hospital, people that needed wards that didn't have them. And in 98, when that sunsetted, you had different companies start doing it. And I think we need to look at that and see if we need to bring the Office of State Public Guardian back and go from there.
So how many, if I don't mind me asking, how many different entities are there providing this? And how many different entities are overseeing this? I guess
That's a no.
confusing.
I'm a guardian myself. So you've got a bunch of individuals. You've got, I know of one company that's doing this in the state right now. And I've heard that there's other ones are trying to start up.
Okay.
But that's what we need to do is make sure that the wards are taken care of. Their assets are not taken from them. You know, you've got somebody, I'm a guardian of 2 people, and it's a full-time job at times. Because, you know, I see my son at least once a week, talk to him every day. When we got off last night, he was FaceTiming me on my way home. I talked to my daughter at least once a day, twice a day, and we're over to their group homes once a week, maybe twice a week. But that's me. There's case managers out there that are guardians of their ward. They're not charging guardianship fees. They're case managers, and they've been a case manager for that individual for 15 years. It so happens, something happens and they take over guardianship. They're not charging fees to that individual. they're just doing it. You know, they might charge $75 to file the court fee to say, this is where he's at, this is how the individual's doing, this is where his money's being spent. Because they're not their payee, they're his guardian. And, you know, that's the thing, this is a very, very, this is a hard subject. Like I said, this was draft 11.
Sounds like it's all over the place, so I'm sure we're gonna get educated today,
Yeah,
Representative.
and, you know,
Campbell.
we need to take care and put some, protections back in. And,
So we're really looking at protections for the ward, structure
Yes.
for the guardians, and guidance where it needs to be all in place. So putting some structure to the whole process, really. Sounds like it's a little bit the Wild West, feels like to me, but Representative Campbell, please, you have a question.
Thank you, Mr. Chairman, and thank you, Representative Stivar, for doing this. I just want to run through a point of clarification to make sure that I'm catching what you're throwing, so to speak. Let's put this very plainly. What we're trying to do is if we have, like in the instance that you used as an example with your children, if you have a handicapped individual that you are the guardian for, and something were to happen to you, what this does is says that if you as the guardian, something were to happen to you to where you cannot fulfill that role, this puts specific this puts actions that whatever agency, whoever steps up into that guardianship role. And if you as a parent were to go away and your handicapped son or daughter was to still exist, and there was nobody in your family to take that role, that ward, what this does is this makes whoever takes that role, this says you must do this. You must meet with them. Okay, I got it. Thank you very much.
Representative Stivar, please.
yeah, and that his needs are taken care of. That, you know, they don't go in and take, you know, half of his Social Security benefits. That's excessive. And that it's consistent because, you know, I know my kids, I know their medical background, I know everything. And, you know, I use my guardianships as, for their medical stuff and a safety issue. You know, that they don't harm themselves, they don't have things they're not supposed to have. Years ago, I used to go to Evanston when I had him in a group home in Evanston. And I'd travel through there on the railroad. I'd stop and go through his room and take knives away, swords away, crossbow. I mean, he doesn't need to have that stuff. You know, lighters. I mean, and that's what the guardian needs to be doing, is taking care of the ward, making sure that their needs are met and they're not taken advantage of. It's just not a number on a sheet going, yeah, check mark, yeah. But there's a whole nother issue on that. And I've had conversations with a few of the district judges and stuff. Also, I didn't have, I'm still working on amendment, and I'm working with Senator Nethercott on that. It is getting put in here a bill amendment for fiduciary responsibility. I even took this up to the AG's office. And that was his only thing. He liked it. Says I'm on the right track. But he recommended fiduciary responsibilities somehow put in there. And I don't think any of you guys were here. Oh, yeah, we have Representative Storr that was here when we spent 4 hours on knowingly on the House floor. Because when he said that's the first thing I thought, that's a legal term. And it's like, oh. So that's why I'm working with Senator Nethercott. She's a co-sponsor on this to make sure we get some kind of fiduciary responsibilities, which will help protect the ward's assets even more, is my understanding.
So do we want to, any other questions for Representative Stivall, Representative Riggins, please.
Thank you, Mr. Chairman, and thank you, Representative Stivar. And we're just talking about your story, and I'm looking forward to a few other people testifying, and we'll give you a larger picture here coming up in a minute, I hope. Thank you.
I have some constituents here to have a conversation of their responsibility, their experience within the guardianship corporation.
Yeah.
Or guardianship.
So other questions for Representative Stivar? I think there's other people in the room who want to speak to this, and maybe we need to, so the thoughts on that? Let's go ahead and please fill the chairs for those of you who want to speak in the room, departments. Are there departments first we need to speak, or? Well, I don't think we really have do we have a department to speak here? Oh, we do. Okay. Very good. Perfect. Thank you, because this is maybe a little bit new territory for the Revenue Committee, so we're all learning right here as we go a little bit.
Good morning, Mr. Chairman, members of the committee. My name is Christy Gordy. I'm the Senior Administrator of the Social Services Division with the Department of Family Services. And again, just here to educate, provide some information as how this proposed bill relates to the work that we do within the department. We appreciate the amendments we just heard Vice Chair Stivar put forward and think they will alleviate the concerns and conversations we've had. But just for the members of the committee, the Department of Family Services is involved in guardianships in two different ways. So the first way is really in relation to what you heard Representative Stivar talk about. There are vulnerable adults that have come in through an adult protection space with the Department of Family Services that may need guardianship. The department then will pay for guardianship. It is a very last resort. It is always the goal for that vulnerable adult. And again, vulnerable adult can be anyone over the age of 18. I think that's important to say because a lot of times we think solely of our elderly population. So definitely the elderly population, but we do have a lot of guardianships that we are involved with for that population of 18 to 21. We purchase guardianship services, so we pay fully for a guardianship. So that it's not tricky, but it's complex. So there's two different things we pay for in that type of guardianship. We pay for the establishment of guardianship, so legal fees, things to go through the court, and that happens under Title III, which is the statute in front of you. And then along with that, if there is ongoing fees that need to happen or be paid, we will pay for those ongoing fees for that guardian. We have a second space, which is important. This is the piece of the bill that was very important to us that we wanted to have a conversation about was the USC reference and the payment, which was $55 solely because our guardianships, we pay much more. So the second space for guardianships for us are with our minors. So a child that may come into protective custody under Title 14, if a permanency plan is decided that it is guardianship, those guardianships actually then take place under Title III. So even though the initial action happened under Title 14, all things guardianship happen under Title III. So then all things in Title III really do mandate what happens within that guardianship, including payment. So when there is a guardianship, there is a potential subsidy or assistance payment that goes to the person or persons who is now going to be the guardian for that minor that is going to no longer be in the protective custody of the department. So it is a new permanency plan, but the department can pay ongoing guardianship assistance to those new guardians of those minor children. So, and in those instances, we just wanted to have the conversation to educate. With the amendments, our concerns are alleviated if those go through because the $55 was going to be a real concern as our payments for guardianships and all those aspects are much more. Around $370 is our average payment for the minor guardianships and just over $600 when we talk about our vulnerable adult space is what we currently pay for those guardianships. And I'd be happy to answer any questions that the committee might have.
And was your last name, was it Gord?
Gordy.
Gordy. Okay, I did write it down correctly. I wanted to make sure I got it right. Thank you, Miss Gordy. And I'm sorry, I didn't catch that. Questions for Miss Gordy? So I have a few questions.
Sure.
So So one of the issues, so when you say you pay that for a guardianship, so is that like a monthly payment, a typical monthly payment that you make for a guardian to do this? And is this something that you have a consistently applied amount for that, the child versus the vulnerable adult? You have a consistency applied approach, correct?
Yeah, Mr. Chairman, yes. And just for perspective, excuse me, consistency, yes. And just for clarification on the vulnerable adults, we contract with an entity who then provides the guardianships. So we have a contract in place with them. We pay them through contract. They then pay that monthly guardianship. There's, of course, reporting and other responsibilities that are a part of that contract so that we can ensure that the vulnerable adult is receiving the services that they need, to include things that we've already talked about that this bill is trying to ensure, such as monthly contact or more if that is needed. Ensuring it's helping them, because if somebody's in a guardianship at this space, it is because they can no longer make some decisions for themselves. And so part of that is to ensure the guardian is making and helping make those decisions. Some of it is to ensure their assets are protected and that there's not things like financial exploitation. So there's a lot that comes with that contract and reporting from the entity that we contract with as it relates to the guardians that they then pay with the money that we do. Now, the ones for the minors who are going into guardianship, we, the agency, will negotiate those amounts with the parent, with the new, not the parents, but those that are going to become the guardian. It gets pretty complex in that there are some eligibility requirements based on if we're going to use some federal funding or if we're going to use state general fund for that. But it is a negotiation, and on average, so there is consistency to that. So on average with those, we see that $300 and about $75 a month for those types of guardianships.
How much of this guardianship process is under your domain, if you will, and how much of it is elsewhere? For example, I guess I would even ask Representative Stivar, are you somehow under this umbrella of guardianship, or is that separate? Because that's an area I'm curious about. Please.
Go ahead. Ladies first.
Mr. Chairman, it's a mixed bag, honestly. I think, and you might hear from others in this space, there's a lot of different spaces when we talk about guardianship. For the Department of Family Services, we are involved only when a minor is in our care for those types of guardianships, or a person has been identified through what is called an adult protective services case that comes to the Department of Family Services to look into or to help provide services for those vulnerable adults. If in those instances, a guardianship is decided that is necessary, then the agency can step forward. So I would say ours are pretty limited to those individuals that are coming into contact with the department through those mechanisms. There are many other spaces such as Vice Chair Stivar and others in which guardianships are happening outside of us.
Outside of your domain. Okay,
Yes.
because I could imagine where this gets very complex once you start stepping through these different bits and pieces. Representative Ricketts, please.
Thank you, Mr. Chairman and Ms. Gordy. Are there different levels of guardianship? I mean, could you have a care version, and then when you talked about fiscal responsibilities, do they all have the same types of responsibilities, or are also those spread out in any manner?
Mr. Chairman, Representative Riggins, I'm not sure I'm the best expert to answer that question, and hoping maybe there's some others in the room to do that. I think there is potential for some variety depending on the needs of the ward or the person receiving the guardianship. But I think there's some standard things within the statute today that are required of the guardian that they all have to follow. I don't know what the ins and outs of each of those are.
So I think what we'll do, I think there are maybe many experts in the room. Please, Ms. Gordy, don't leave. You'll probably have many more questions. But I would like the experts to please fill the chairs if you can. I think it would be good for us to make sure we've got a broad understanding of this. I have a feeling there's going to be a long conversation. We always hope for the easy ones, but that's okay. It's very good. Thank you all for stepping up. So please, other questions? And let's do this real quick, maybe just if each one of you would take a moment to at least introduce yourselves and maybe give a quick summary of the hottest topics, I think it would be valuable for each one of us. And so maybe a quick introduction, a quick summary of where your expertise may lie, might give our committee an opportunity to know where and how to ask questions. So thank you. Please.
Mr. Chairman, committee, my name is Beth Lance. I'm with the Wyoming Trial Lawyers Association. Our association has a full section of members that are family law attorneys, and family law would be where guardianship and conservatorships lie under the law. And so we have many members that practice this on a daily basis in primarily the private sector. I personally also am an attorney who does guardianships, so I have my own personal knowledge that I'm more than happy to share today. Just a couple things to point out, because there have been a lot of questions so far on this, Mr. Chairman, but it's important to understand there's guardianships and conservatorships, and they are not always together. Sometimes you have both. Sometimes you are a guardian and a conservator. Sometimes you are just a guardian, and sometimes you are just a conservator. So it's important to understand that those are different under the law. A guardianship is what we think of where you have the duty then of care. And a conservatorship is the duty of watching over that person or that ward's finances. So those are two different things that don't always coexist. As you can imagine, when we're discussing guardianships of minor children, particularly minor children who may have come through the state system, they probably come with no assets. And so just a guardianship is typically necessary under those circumstances. Now, there are times where children may come under a guardianship because of the loss of their parents, and maybe there was an estate that was left to that child. And so then we may be looking at a guardianship and conservatorship because that person may be also handling the estate on behalf of those minor children. So it's important to understand there are many different things happening here. And again, we are talking about guardianships and conservatorships for minor children and incapacitated adults both. And those often look quite different, as you can imagine. When we're looking at these additional reporting, my point to that would be that when we see now we're looking at this monthly contact, you can imagine there are a lot of circumstances in which a daughter may live in California. Her parents may be well taken care of in a nursing home here in Cheyenne, and she's, I'm sure, in contact with that nursing home, and she's able to report through them how their parent is doing under that guardianship, but they may not be flying back to Cheyenne once a month for that in-person contact. And I think there's some concern that that's an additional burden for some people. Additionally, if you have a minor child that lives with you, we're having constant contact. You're raising a child. And so monthly reporting also under that situation seems somewhat unnecessary. The statutes currently do require reporting every 6 months, and that reporting currently does require you to speak towards the physical and health and well-being of the ward. And so that is occurring already. Additionally, when we're looking at fees to guardians, terms like reasonable are better because those end up being set by the courts. So I want to be clear, that's who's currently making determinations as to whether those things are being done reasonably. And so through these reports every 6 months, the courts spend time, they read these reports. I know they do because I've been called in on follow-up to answer questions about these reports. And so the courts are keeping tabs on all the wards in the state and are looking out from their perspective for the best interests of these wards to ensure these guardianships and conservatorships are working for the well-being of our incapacitated adults and minor children.
Thank you. That's actually very helpful. So the just real quick, and we'll introduce everybody. So you could have a guardian, you could be either or you could be both or either one?
That's
And
correct,
so-
Mr.
and So, okay, I got you. So very good. Please. I'll get you all introduced.
Mr. Chairman, members of the committee, I'm Emily Smith. I'm the CEO of Wyoming Guardianship Corporation. We are a private nonprofit who serves the whole state of Wyoming. We've been providing corporate professional guardianship since 1997, since the sunset of that legislation that Representative Stivar mentioned. And I also have a national guardianship certification. I've had that since 2011. And so that is my introduction.
All right.
Good morning, committee. I'm Reagan Latham. I work for the Wyoming Department of Health. So today with the amendments, I think we are feeling much more comfortable with this bill, but I'm happy to work with the sponsor on any questions. For us, we oversee Guardian or kind of cross there with our Wyoming State Hospital and our Wyoming Life Resource Center. So both of those facilities have individuals who at times do need guardians. So we do contract with Wyoming Guardianship. For your awareness, we do go out for RFP for these contracts around every 3 years. We have only ever had one responder to provide those guardianship services. So we contract very much like Department of Family Services for those legal fees. If we can have family guardians, that's always our first choice. And then if there is no one available there, then we would pursue Wyoming Guardianship as that guardian. So happy to stand for questions.
What was her name again?
And sorry, I missed your last name.
Reagan Latham.
Reagan. Very good. Representative Campbell, you had a question.
Yes, I am going to dial in here specifically on guardianship, because the concern that I'm seeing here is, let's say we go from that minor guardian and now we're an adult and we don't have any family members. So my question is, my concern is, as a guardianship, these people are receiving funding to ensure that these people are cared for, to make sure. And I'm just curious, how do we verify what is done? You know, if somebody has a traumatic brain injury, or, I mean, there's so many, like you said, this is all over the board. If you guys could tell me, where are the consistencies? I mean, we have a whole lot of things going on, but where are the consistencies? Where can we see common ground with all this?
So I'll let whoever feels like they want to jump in on that difficult question, please proceed.
Chairman Locke, Representative Campbell. Excuse me, I'm just getting over being sick. So right now, the way that the court oversees that is the court is determining that through reporting. So the every 6 month reporting that Ms. Lance talked about, the court is reviewing those reports and determining that people are doing their job under the statute. Now, I think it's a little bit different when you talk about Ms. Gordy and Ms. Latham, the Department of Health and the Department of Family Services. That is a contractual agreement specifically with Wyoming Guardianship Corporation. And so I think they are determining through our contractual requirements whether or not we're doing our job. So we have several layers of people, but for just regular guardians, because there's family, there's volunteers, there's professional guardians. There's a lot of professional guardians in Wyoming. There's only that we're aware of one corporate guardian, and that's my organization. That's the court that is overseeing that and determining whether or not people are doing their job.
Representative Campbell, please go ahead.
Thank you, Mr. Chairman, and thank you guys for coming here. This is an important deal. I just want to follow up a little bit to where, how do you guys work with each other? And Ms. Latham, like, for example, with you guys administer the community-based in-home health services, I believe, and also the Title III National Family Caregiver Support Program. How do services like that have respite services in homemakers, and somebody like I think it's Wyoming Independent Living Services, how do you guys communicate together to provide holistic services? Thank you.
Ms. Latham, please.
Mr. Chairman. Representative Campbell, so for me, I oversee the Behavioral Health Division, so that includes the State Hospital and the Wyoming Life Resource Center. We do work collaboratively with our home and community-based waiver teams. So typically if someone needs a guardian and they come again into the State Hospital or the Wyoming Life Resource Center, that's where we would kind of interact. We do work also with Adult Protection Services through Department of Family Services. So when someone needs a guardian and they come onto our radar, you're typically seeing them maybe in your criminal justice system, or you're seeing them in our Title 25 system. And that's where, again, the courts are making that decision, or our clinical staff are saying, hey, this person has maybe been in and out of the system a few times. Clearly, we need a little bit of help with some decision making. And that could be housing, what providers to pick. There's a lot of things that guardians really are in control of, which is why we take it very seriously. Does that answer your question? Thank you.
All right. Other questions for anyone on this board where we have a bunch of experts in front of us? And I would warn you, sometimes coming before the revenue committee, you're talking a bunch of numbers geeks, so you got to worry about us a little bit. But this has actually been very helpful for me. But other questions for them, Representative Lane, please.
Thank you all for coming today. I believe you said your name was Emily. My question for you, having a National Guardian certification, is how does this line up with our national standards?
Please.
Chairman
Smith.
Locke, Representative Lean, that's a really great question. The National Guardianship Association puts out standards of practice. There's no requirement in Wyoming that the guardians have to follow those. Guardianship is not a federal concept. It's a state by state concept. So every state has a different statute, which makes it really hard. And we all know that some states have some wild stuff going on. And then some states, our state is not as complicated as, for instance, California or Washington. Some of those states require that guardians adhere to the National Guardianship Association standards. Some of those states require that guardians, professional guardians, have a certification or a license. So I guess it's kind of a complicated answer, Representative Lean, because there isn't, we don't have those requirements. But if you look at the National Guardianship Standards and Practice, they do echo a lot of the things in our statute already. And so professional guardians hopefully would be following those. They are much more extensive than our statute is, but they do echo each other in a lot of ways. So,
other questions for these Representative Campbell? Sorry,
Thank you, Mr. Chairman, and thank you. You said hopefully would follow. Is there not rules in place that would dictate that that is going to occur?
Chairman Locke, Representative Campbell. There is no part of our statute right now as it stands for guardianship that requires guardians to follow the national standards of practice or be certified or licensed. So that's why I said hopefully. I think my personal opinion is that all professional guardians, corporate guardians, people who are getting paid to do this for a living should be following those. There's nothing in our statute that requires them to follow those.
Thank you. No further question.
Thank you. That is actually very helpful. Representative Riggins, please.
Thank you, Mr. Chairman. Anybody can answer these questions. One of the ones that, have you looked at the bill? Just curious. All right. So I was looking at just page 2 when you mentioned about contact, monthly contact and so on and so forth. So it said in any reasonable form, and simply I just added in there and said, and it erased all that, but verifiable monthly contact. I didn't put a date on it at the time, and it looks to me like that's what we're attempting to establish, if it's verified. Because I've seen situations exactly you're talking about, especially the one that she brought up about not being anywhere near there. A similar situation. My own mom, 100 miles difference from my sister. So, because there's neighbors and there's other people, and for example, sometimes you have a nurse that stops by every week or two to check on something. Those things are probably evidence of contact, right? So I would just wonder your thoughts on that. And there's probably a few other things in there. But maybe just address that first.
Mr. Chairman,
Right.
Representative Riggins. I do believe with the amendment that Representative Stivar has proposed, that it definitely improves from the original language of the bill to attempt to account, I think, better for those situations. But I would just say in general, without any change to that, there is that 6-month reporting requirement. And I guess I'm unsure where the problem lies.
Representative Reagan's. Follow up. Excuse me.
Thank you, Mr. Chairman. And for the most part, we're talking about people that are either being paid or appointed, designated as guardians. And I wonder how much sometimes this is just family members are usually the most frequent guardians. And I wouldn't want to hamper that. And of course, if you have families and you guys are probably as familiar as anyone, there's lots of conflicts in that world at times, right? So I could see people using these statutes and then accusing another family member of not making contact, things like that, that are put in statute and it's entirely family related. Anybody want to comment on that?
Please, whoever, Ms. Lance.
Mr. Chairman, Representative Riggins, no question. In the private sector, we see lots of disputes, particularly caring for parents, right? Because there's probably multiple siblings and one person is stepping up and there may be disputes. So no question that happens. And I think that you're completely correct in pinpointing that sometimes when we begin to have very elevated requirements such as that it may cause more problem than solution.
So this is really that fine line where we don't want to create so many rules that it's darn near impossible to administer and function. You know, I don't think we want to cross that line. At the same point, if there are true gaps in care, please, Representative Reagan's.
Thank you, Mr. Chairman. With that conversation, would we intentionally write these statutes focused purely on the people that are paid or court appointed? And any comments on that?
Mr. Chairman, Representative Riggins, no, these statutes are global. They are, they include both the private family situations and the guardianship situations, which include these other colleagues of mine here that either work for the state or for the Nonprofit Guardianship Association. But I would wager to guess that the majority are handled within families. I think it's an exception that there isn't a family member that just steps up for free for either a minor child or a parent or an incapacitated adult. As I believe Mr. Chair, Representative Campbell had brought up or alluded to earlier, there are times where we may, any of us could have, as Representative Stivar, I believe, does a child that has special needs. And as they become an adult, we need to maintain guardianship over those children due to their special needs, traumatic brain injuries or otherwise. Obviously, a myriad of things could be happening as to making them an incapacitated adult. Sometimes mental illness is so severe. And so in those situations, often as a parent, you go ahead and get a guardianship over your own child as they become an adult so that you can make those decisions, because while they are legally 18, you don't believe that they're capable of making adult decisions for themselves or caring for themselves. And so I would say those kinds of situations are probably the majority of guardianship and conservatorships that exist.
Representative Campbell.
Thank you, Mr. Chairman, and thank you guys. As you guys are explaining this, that everything is so vast, is there any kind of tier structure to where somebody who may have a cognitive disability, let's say they have an IQ of 58, 60, as opposed to somebody who has a traumatic brain injury. As I'm seeing this right now, these people are classified kind of as the same in this guardianship program, yet the person with the cognitive disabilities may be able to continue on ADLs effectively as an individual, where the person with the TBI may not. How do you guys, because I mean, I'm seeing worth paying $600 that we've got to report to the courts once every 6 months. And I mean, that sounds nice, but that is not doing anything to ensure the quality of care of that individual. So is there a tiered structure? Is there a prioritization? How does that go? And how do you guys rectify the differences in the disabilities? Thank you.
Mr. Chairman, Representative Campbell, I'm going to back up and explain a little part of this process. So in order to have a guardianship or conservatorship ordered, either the ward consents as an adult and they consent to that occurring, or you go to a hearing, they are notified, they can attend the hearing. So if someone is cognitively maybe borderline, the judge has to determine whether they truly are incapacitated and whether a guardianship or conservatorship should even be ordered in the first place. And so that's where that decision is made. It's made initially by the courts as to whether it should or should not exist. But then once it exists, the requirements must be followed by the guardian or conservator in order to ensure the care of that ward.
Mr. Chairman, thank you. So I'm just trying to wrap my head around this. So it is the court system that says, okay, they kind of set the precedent of what the care requirements are for each individual. Is that correct in saying that?
Representative Campbell. Again, this is an incredibly complex subject. So I'm going to take kind of your before question and then your next question. And if I don't answer something, please let me know. My memory isn't super great. But when you talk about, you're talking about people that have very different, wildly different disabilities and capabilities, right? Somebody who has dementia and lives in a nursing home is going to be different to take care of than somebody who lives in their own place and has a brain injury. Those are going to be vastly different. And so I don't know that our statute addresses that in specificity, but the court certainly knows that from the original hearing and the original guardianship. And to your second question of the first set of questions, the statute provides for limited guardianship, and Beth can answer this if I misspeak, but limited guardianship is the court order would limit the guardianship to specific things. So just medical decisions or just housing related decisions. So if the court felt like that the guardianship didn't need to be plenary, which means full, they could limit it in some way. Now,
I'm
sure.
going to interject for
Yes,
just a second because we're, Mr. Chairman, as I was.
Yeah. Go ahead, please.
I just want to clarify where I'm going is I'm looking at the common ground that we're giving these guardians $600 for an adult, $375. Let's say $600 for an adult, 6 months, that's $3,600 to make a phone call. Where is our guarantee that the ward is, I understand the court say, we got to follow up. The courts say we got to do this every 6 months. We're paying $600 a month. That's $3,600 for a phone call. What are we doing to ensure that that ward is in fact being provided for is my question.
Chairman Locke, Representative Campbell, if I could tell you a story for just a second, I hope that it might illustrate that this is not phone calls, and it might help you understand what being a guardian actually is like. I know Representative Stiver talked about being the guardian of his children, and I think that was very valuable information. But let me tell you about one story of many that we have for Wyoming Guardianship, and then I think Ms. Gordy can address some of your other question as well. So in 2024, Adult Protective Services reached out to Wyoming Guardianship about a young woman who was in the local hospital in her community here in Wyoming. They became involved when law enforcement brought the woman to the hospital after they had arrested her caregiver. This young woman was being sexually exploited and sexually abused by her caregiver, who was also her dad. Her mom was in a nursing home and she has no siblings. After the hospital ensured that she was medically stable, they were unable to discharge her because she had nowhere to go. She has a developmental disability and was unable to make safe decisions for herself and had no one to care for her. She spent weeks, probably months actually, at the hospital where the staff tried to figure out the best way to keep her safe. When the guardian, Wyoming Guardianship, was appointed by the court, we began working diligently with the hospital to get community services and programs in place for this young woman so that she could be discharged from the hospital and go be a vibrant part of her community. She was placed in a program for young people with developmental disabilities that has a strong emphasis on community involvement and activities. We ensured her admission and her placement into this program. We coordinated paying for the program, and our staff visited her frequently and continues to visit her frequently, coordinating with her providers, her medical providers, her mental health providers, and her case manager to ensure that she continues to do well. She now has hobbies, she's made friends, she enjoys her life, she receives appropriate physical and mental health care. And if you ask her, she will tell you that she loves her life and is happy. So if you know one story about guardianship, you know one story about guardianship. As you can see, Representative Stiver's story is very different from the one that I just told you, but this shows you hopefully the breadth of these types of cases that we're talking about. And guardianship is absolutely not about making phone calls. And I want to just be clear that I don't think anybody's getting paid $600 to make a phone call. And I understand the intent is to make sure that there's not a bad actor that comes in and does that. I wholeheartedly support that. Wyoming Guardianship would support anything that would do that. And I don't know if there's an answer about how you really prove that someone is not a bad actor and is just making a phone call for their payment. I do know that the statute currently has a section about complaints. It addresses very specifically how you can complain about your guardian and the judge, how the judge has to respond to that complaint. So I'll let Christy answer the rest of that question.
Yeah. Representative Stiver.
Thank you, Mr. Chairman. Who has the ombudsman for that right now? Who has the contract?
Chairman
Yes.
Locke, Representative
Yeah, but-
Stiver. I don't know what, could you explain your question better? Because I'm not sure I understand.
I would like to know who has the ombudsman contract or grant for that exact complaint?
For the long-term care ombudsman or for the,
Mental health ombudsman.
oh, the guardianship complaints are not covered by the mental health ombudsman. The mental health ombudsman and Reagan, sorry, I keep saying you guys need to probably have some answers for this, but the mental health ombudsman is a specific program that is for advocacy and mediation for people that have concerns or complaints about their mental health treatment. Guardians should not ever be providing mental health treatment. So my answer to that question, Representative Stiver, is the mental health ombudsman is not in any way statutorily allowed to investigate guardianship complaints. We don't have an ombudsman to do that right now. Right now, the court is who investigates guardianship complaints.
Okay, and Ms. Gordy, you were going to answer some questions there as well. So let's do that. And one thing we might do, we might kind of wrap up this part a little bit because I think there might be some public that wants to at least give their some examples. And I think we probably at least need to hear that and get that on the record. But thank you. Please proceed.
Chairman Locke, thank you. And this is to Representative Campbell's comments and questions. So just wanted to chime in from the Department of Family Services and make clear the numbers we gave you were the numbers that the Department of Family Services pays. So I just want to make sure that that's we're not representing that across all guardianships, as we know that it's vast. But I would say to your question about how do we know what they're doing, I will speak very specifically to the work we're doing because we do contract with Wyoming Guardianship Corporation. Part of that contract, as I mentioned earlier, is there are requirements that we meet monthly with the Guardianship Corporation on all guardianships that we are paying. We have expectations through that contract about those needs. Those things are determined when, I think to your question, I can't get into whether they have a TBI or dementia. That's out of my realm of expertise. But what I do know is there is work done in the front end from an assessment perspective of what are the needs of whether it's the vulnerable adult or in our perspective, the minor, what are their needs? And then what is it that the guardian will need to do? But also what is it that the guardian needs to have in order to provide those services? But we then do follow up on our vulnerable adults with the Guardianship Corporation to ensure they're receiving those services or that they are getting what they need. And we do that on a monthly basis with the Guardianship Corporation. We also know the guardianships in which we are involved with or that we pay for are seeing, because we're requiring monthly contact. Sometimes it's weekly. It just depends on the needs of the ward and the expectations of those guardians through those guardianship services.
Okay. So let's keep it short because we need to move on. Okay.
Thank you, ladies, again for coming here. I just want to clarify, I'm not insinuating that anybody's doing anything nefarious. I thank you guys for everything that you do every day. But what I am seeing is that we don't have any set of rules right now, and you guys are all working together, it sounds like collaboratively, but there's really not a structured set to it. So this has really opened my eyes to a lot of things. I thank you guys for your time.
Thank you. And seeing no other questions, I want to thank you for coming in here and you realize you're educating a new group of people. So, but this is very helpful. And thank you so much.
And I want to thank you for coming. Thank you.
Please. I really appreciate it. Excuse me. Please, the public, people who want to get up and speak, we would love to hear more and understand the broader picture, whoever wants to come up and speak to us over here. If anybody in the public. And Mr. Laycock and whoever. Go ahead, just go let her know. Let's fill the sheets and we will probably try to, if you guys don't mind, we're gonna try to keep it a little tight, maybe 2.5, 3 minutes-ish. Just so everyone can speak. I want to make sure everybody gets a chance to speak. If we have more time, we'll use all the time we have. That's not a problem. I'm not trying to cut anybody off, but try to please proceed and start whoever wants to jump in first, please.
Mr. President, or Mr. Chairman, sorry.
It is all right.
Committee. My name is Kim Elfring and I'm from Cheyenne Habilitation. I personally do work with Wyoming Guardianship, so I have experience with them. And I do feel currently the current guardians that we've had in the last couple of years have been exceptional. They do make contact with the people that we do services for them. We make sure, and we do a plan of care, and we make sure that in that plan of care, it's outlined of what that person needs. And then we try to fulfill those needs to make sure their basic needs are being met and going over and above to care for them so that they can have the exceptional life. That's how I feel like we do.
And your last name, I'm sorry.
It's Elfring, Elfering.
Thank you.
Your agency?
Cheyenne Habilitation.
Great. Please.
Good morning, Chairman and representatives. My name is Kristen Taylor. I'm a case manager for the community-based waiver. I have several participants on my caseload who also have professional guardianships. Yes.
Good morning, Mr. Chairman, Representatives Committee. My name is Victoria Snook. I work for Humankind, which is a waiver provider for the DD population. I have been with that company for 10 years, working with our individuals who are on the DD waiver receiving services. We have, of our people that we serve, we have 21 that we serve. 33% of them have family members that are their guardian. The other 66% have guardians through Wyoming Guardianship Corporation.
All right. Mr. Laycock, how are you doing? Welcome.
Well, thank you, Mr. Chairman. Good morning, Chairman and Committee. I'm Tom Laycock, Associate State Director at AARP Wyoming. We're a membership organization for those over 50. In very broad terms, our concerns were actually have been aided by the amendments that we've seen. It was our concern that requiring a monthly in-person visit could be difficult for some of our out-of-state guardians, and appreciate the opportunity to have those visits done virtually when necessary. Our other concern was simply availability of guardianships in Wyoming for Wyomingites who find themselves in need. As you're well aware, adults placed under your guardianships can lose basic civil liberties, including how to spend money and medical treatment. For that reason, guardianship should be the last option of resort, or the option of last resort. That said, guardianships can be necessary when there's no family or friend who's able to help someone take care of their affairs. Now, for 2 interim periods, I followed the Mental Health and Vulnerable Adult Task Force across the state. As the committee talked about everything from the definition of vulnerable adults to guardianships in the process itself. One of the things that we talked about in that committee right off the bat was an informal poll of DFS caseworkers asking what are the top needs for vulnerable adults. The answer was guardianship and conservatorship services. Incidentally, number 2 and 3 was senior transportation, so keep that in the back of your mind. We understand sometimes there isn't a friend, neighbor, or family member who's willing to stand up and act as a guardian, which is why our paid service providers, that's when they can step in. My ask is, as we discuss the financial piece of the paid guardianship puzzle, to realize there is a need for paid guardianships, and we work to find a solution that maintains those services. So with that, I'd be happy to stand for any questions.
Thank you. So any questions from the committee of this group of folks that we want to ask? So what are do we really have a clear picture? And I guess I'm asking the committee this.
We need to get these 2 ladies up here.
Okay, we'll do that. So, but let me ask a quick question. Do we really have a clear picture of, in terms of the bill and the amendment that has been proposed, do we believe that the amendments that have been proposed have resolved the major concerns? One of them that clearly is sticking out to me, and I'm just asking the committee and everyone here, is this reporting requirement that appears to be have some structure to it. The changes that have made it to where the in-person component of it seem to be the biggest concern. Have we addressed people's fears and concerns with this process? I guess I'm asking this body this. Because again, we want to be ever so cautious about making major changes just for the sake of making major changes. We don't want to make the guardianship any harder, but at the same time, if there are specific protections we're trying to put in place, I think that's where we're trying to get to. And I guess I'm going to ask this group here, have we addressed the concerns with the amendments to this bill? I guess so. We'll let people speak as they choose.
Hi, yes, I do believe that this bill does represent our concerns. A little bit, you kind of talked a little bit about the 6-month reporting process and how we know that the guardians are showing up. I do believe that in my case, they are showing up to the houses. I know that because I am a case manager who is also responsible for doing a 1 hour of face-to-face time with my participants every single month. And as well as service observations and looking into their home. I know that the one concern I have with this bill, or not a concern with the bill, but a big concern with my participants is the cost of that is associated with the professional guardianship. Some of mine have $90 an hour, and that can sometimes add up to $300 a month if they're in trouble with the law, if they're doing reports, or if they have some kind of medical concern that's going on. Many of these individuals are on a fixed income and they're only making $900 a month. So $300 out of what that takes out of their personal spending money. Sometimes that takes out of what they might need for shoes. Other, they have to look at going to a dance that's $25 or getting a haircut. They have to make those changes because they don't have the money for it. There are times that when we've had conversations that the guardianship there'll be a $300 bill and maybe that guardian, they can't pay it because they have to pay their rent and all of those other things, that they will then go to the pooled trust and take money out of that. On top of that, many of the times the professional guardianships and the payee are charging $90 an hour and $40 a month for the payee-ship. So that's $130 out of this already fixed budget of our individuals. So I guess on my end, it's really making sure that we're not taking more than we need to out of the fixed income.
Okay. That is great. Thank you. Please.
Mr. Chairman, committee members, as my colleague here mentioned, we currently have an individual who is being charged $120 an hour for their guardianship. And just recently, this individual, there was difficulty getting a hold of the guardian for an appointment that guardian was required to be at by the provider. The guardian knew ahead of time of this appointment. It was scheduled with the guardian to make sure that they could attend. Every effort was made, phone call, text messages, emails to contact this guardian to make sure that they were there. And it ended up being that we were not able to get a hold of the guardian. The provider marked down the participant, as we refer to them, as a no-show. They did put down that they were there, but their guardian failed to show up, and that appointment had to be rescheduled. This is not the first time that we've had trouble contacting a guardian and making them available for appointments that they are aware of ahead of time. And we do every effort that we can to make sure that they are aware. Granted, sometimes there are last-minute appointments, but I personally have taken people to go get blood drawn. I've notified the guardian, hey, I'm going to take so-and-so on this day to go get their blood drawn that their doctor has ordered. And they say, okay, not a problem. I'll be available. Do you know what time? And I'll say, yeah, we're going to go about this time. And then the lab will call the guardian to try to get permission to treat and cannot reach the guardian. So then we then have to turn around and leave and try to reschedule it and get it done again. So, guardianship, yes, it's very important. And these people absolutely do need guardians, but they need guardians that are available at a reasonable cost. And as my colleague has mentioned, there are times that because their finances have been drawn on so much that they are very limited. And there are times that the company I work for has stepped up and paid for some of their things.
Interesting. Any other?
Let's get.
But we do have a couple of additional individuals, I think, that we would like to get up here to the table as well. But any other, did you have another question here? Okay. But don't go too far, please, because I do, we might have questions that kind of span a broad group. You don't have to, but please, ladies, step up on them. Yeah, and I think this is actually a good education. Again, we've got a little time here. We've got to be on the floor by 10. And so we'll probably break maybe just a little bit before 10 and give the body time to take a look at this. But that being said, we're happy to, I think, continue this conversation because I think there's a lot of, it's a big subject and we want to make sure we give it, anyway, please proceed.
My husband and I live with my mother. She's 93 years old. We were asked last year on the 1st of February to move in with her when she was released from the hospital. She fell on February the 1st and broke the femur head off of her right leg. We took her to Poudre Valley because she didn't want to be in the hospital up here. She had just been released from there, where my brother told everybody she was incompetent and could make no decisions. And she didn't like the way she was treated. So we took her down to Poudre Valley, where she was in rehab for 4 weeks, and then brought her home. After that time, my brother filed for emergency conservatorship and guardianship. And we got a lawyer, and she advised us to hire a professional service. So we did. And we were told that my brother then would not be a problem and my mother could live in her home in peace. So we followed the instructions of our attorney. And shortly after guardianship and conservatorship took over, they decided that my mother needed 12 hours a day care, even though we live with her 24 hours a day. We had already hired Home Instead to come in and have caregivers come in. And we had a caregiver in twice a week so that my mother would be familiar with somebody when we had doctor's appointments and had to leave her at the house with somebody. They decided on May the 23rd, I was out of town and my mother and my husband were taking care of my grandchildren, that they would bring somebody into the house 12 hours a day, 7 days a week. I discussed with them the cost and the expense of and how quickly it would drain my mother's bank accounts, and was told that it was being done because they had gotten an anonymous phone call saying we were neglecting and abusing my mother. My husband is a 27-year retired deputy sheriff of Laramie County. And he said it needed to be reported to DFS. And I explained that to the guardianship and they told me they were handling it in-house. And that's why 12 hours a day would be consistent with what they wanted to do. I called DFS and I called Laramie County Sheriff's Department and reported it. And they said it was unusual for the person being accused to call and report. And I said, according to my husband, that's what was necessary to be done. Since then, we have been threatened with eviction 3 different times. We talked to the adult task force, and within 24 hours, I was told to cease and desist. And I was asked to sign a service contract that would allow me no longer to advocate for my mother's rights. And then I was asked to do a mediation, and if I didn't, the forcible eviction they served on me in September would be executed. We're still living with my mother. We're still trying to help her. She has stages of dementia. She has not been declared incompetent. One of the things that just recently happened, January 2nd, I got a notice from the Guardian that my mother's furnace needed cleaned. And I said, well, it's winter time. It's not a really good time to do that. She's 93. When the temperature in the house is 78, she's cold, she has a sweater, and she has a jacket on. They said, we want it done now. So someone came in on Monday and cleaned the furnace and the filters, had the door open for 2.5 hours. The temperature in the house dropped to 54 degrees. My mother got chilled. She was in a winter coat, 2 blankets, and it took 1.5 hours for her to warm up. My concerns are that things are not getting done for the ward. They're being treated like a non-person with no rights. And I was told that my mother has no rights. Nobody will listen to what she wants done. They won't even talk to her about her wishes. I was asked for a meeting to discuss my mother's final arrangements, and she's already discussed it with us. And she said she does not wish to discuss it with anyone else. My father has been gone 6 years now, and my mother goes out and puts flowers on his grave. We take her out there. The guardianship called her caregiver and asked them to do that Memorial Day. And they told us that they told them no, they wouldn't do that because that was a family matter and didn't require guardianship to intervene. Every time my mother has a guardian come, she also has a conservator. Another concern of mine for the money situation, because the conservator charges $150 an hour, the guardian charges $90 an hour, plus 90 cents a mile per vehicle. I don't understand the need for both conservator and guardianship when it's a guardianship appointment. And I've asked and I get no response. We do not receive any kind of monthly statements as to how much money is being charged by the guardianship and the conservatorship. We have no idea of how much money is left in her account. Her USAA account was closed totally, and it had to have a letter stating my mother was incompetent. So they took the letterhead off of the top of the paperwork when I tried to file for conservator and guardianship 2 years ago. That attorney got fired for doing that because I asked him not to put incompetent because she is not incompetent. She has not been declared incompetent. She does have some cognitive deficiencies and she does need things explained to her in detail. I contacted Clarence when all of this started and asked him if he could offer me some help because I had gone to several individuals in the state and been told it was a civil matter. I have filed a discharge notice with a court listing complaints and nothing has been done. I was told that I could go to the judge when all of this started. I sent the judge a letter that was returned to me by the clerk of the courts stating that I had to go through proper channels.
I have a question. I don't know if others have a question, but I wanted to ask, how was that guardianship initially put in place if maybe we can?
Court order.
So it was a court order but that was clearly in place before you, for lack of a better term, kind of took over taking care of your mother, at least.
No.
Sounds like, or I'm a
No.
little confused.
I started in February when my mother was released from the hospital, February the 1st.
Okay.
She has some issues with stability. So they said someone would have to live with her. And she asked if my husband and I, who are both retired, would move in and take care of her, which we did.
Okay.
And then after that, my brother filed for
Okay.
emergency conservator and guardianship. And as I said, I got an attorney who advised me to hire a guardian and conservator so that my mother could live the rest of her life in peace. And I addressed with the guardianship the issue of spending $13,000 a month for a caregiver when we were there. And they were sending caregivers from 8 in the morning till 8 at night, 7 days a week. And what I was told was it was because of my brother saying that we were abusive and neglectful, and they were going to handle everything in-house.
Okay, that was a confusing part, and we're kind of outside our realm of what we can do, but this at least helps us with understanding this process. But please understand that this committee probably well beyond our span of ability to get involved here, but hopefully this gives us some context to understand how this process works a little bit. And so go ahead, please.
My concern is that my mother is being treated like a non-person by the guardianship. She is not, no one's asking for her what she wants done. They're treating her like she's incompetent, and they're not asking her what she would like done. They're not asking her. They have now forbid me to go into any medical appointments with her. And I ask, why can I not go into her medical appointments? Because I'm with her 24 hours a day. I give her medications. I need to know what her medical status and issues are. All I get is an after visit summary, which does not state anything. And the reason I was told I can't go in is because we said so.
Interesting. Okay. So please.
Good morning, Mr. Chairman and committee. My name is Stacy Miller, STACY MILLER. I'm a guardian and conservator for my aunt. My end goal is to make sure she stays in her home as long as she's safe and not prematurely put into long-term care. Now, what I was trying to look for is if anything ever happens to me, someone that will have the same goals and care for her and make sure that her needs are met. So I'd like to, and I shortened this as much as I possibly could several times. I'd like to tell you her story, and I'm going to use the third person to hopefully hold it together here. A developmentally delayed elder woman in Wyoming who is illiterate and owned her home free and clear became a victim of severe financial exploitation. Her niece discovered the severity of the abuse when her aunt asked her to read a mortgage delinquency notice. Investigation revealed over 4 years, 5 separate loans totaling more than $100,000 were taken out in her name, co-signed by her brother, that provided her no benefit. A portion of her property was also sold during this time. Despite clear evidence and repeated requests for intervention, multiple state agencies failed to adequately protect her. The bank that funded the loans had a long-standing relationship with the victim. They had knowledge of her illiteracy and inability to manage her finances and her Social Security representative payee status. Despite knowing these vulnerabilities, the bank processed multiple loans totaling over $100,000 against her mortgage-free property, allowing her brother to bring her in to code-signed documents she could not read or understand. The bank did not question why someone with no financial management history was suddenly taken out significant loans, failed to implement safeguards, and did not report suspected financial exploitation, despite clear red flags. In May 2019, a quit claim deed added the brother as joint tenants with rights of survivorship to the victim's property. The financial exploitation began almost immediately. By September, an unsecured loan for $8,100 was funded, followed by the first HELOC for $40,000. When Adult Protective Services received a report in March of 2020, law enforcement investigated but closed the case as unfounded. Critically, the exploitation didn't stop. Instead, it accelerated. In December 2020, another HELOC for $65,000 was approved. By January 2022, a mortgage exceeding $100,000 was taken out with a property valued at $135,000. And this property value was located on the loan documents. In April 2023, a final HELOC was originated for $18,000 with approximately $11,500 drawn from it. Throughout this entire period, the brother misused the victim's Social Security funds and took control of her assets. The victim did not benefit from any of these loans. When a small part of the property was sold in July 2021, the victim's share was taken directly from her by her brother. The brother passed away in the summer of 2023. But by then, the damage was done.
This is new. We don't have this normally, but.
Sorry. Oh. The niece was told repeatedly that this was a civil matter, not criminal. However, Wyoming law clearly establishes that this conduct constitutes financial exploitation of a vulnerable adult and criminal misuse of Social Security funds, as well as some civil pieces. Every Wyoming agency the niece contacted was either dismissive, rude, or ultimately unhelpful, passing her from one office to another without anyone taking responsibility for protecting this vulnerable woman or investigating the full extent of the crimes against her. When evidence is clear and family members are actively seeking help, but justice is denied due to possible personal connections, it raises fundamental questions about whether Wyoming law truly protects vulnerable adults. If families cannot access the investigative resources needed to identify all perpetrators because the system refuses to thoroughly investigate, how many other connected individuals profit from exploiting without consequences? When the system's response is refusal to investigate rather than uncovering the full truth, it suggests the priority may be protecting certain individuals from scrutiny rather than protecting vulnerable adults from harm. Okay. The victim suffered emotional devastation and reoccurring nightmares, reliving trauma from childhood sexual abuse. She was institutionalized from her nervous breakdown when she was a child. This nervous breakdown came from, don't tell anybody, don't tell anyone what was done to you. Her home, the one stable asset left by her mother, the one place she feels safe, became encumbered with loans she could not read or understand. Law enforcement mischaracterized criminal conduct as a civil matter. State agency failed to fulfill their protective mandate. The full scope of exploitation may never be known because the system refused to investigate, and other perpetrators may never be identified or held accountable. The exploiting brother's dismissive reaction to weak warnings demonstrated his confidence that meaningful consequences would not follow, a confidence that proved entirely justified. The message sent was clear: connections matter more than crimes. This is not just about one vulnerable woman and her home. It reflects what Wyoming stands for and who Wyoming chooses to protect. When systems fail to hold connected individuals accountable, it signals that some people are above the law. Families are left bearing the full burden, paying attorneys for civil cases that should have been criminal prosecutions, spending thousands navigating unresponsive agencies and exhausting their resources while perpetrators face no consequences. This case demonstrates the urgent need for mandatory external review of all vulnerable adult exploitation cases, and independent prosecution authority that cannot be overridden by local connections. House Bill 101 demonstrates genuine courage by standing with families and vulnerable adults who've been failed by our system. Mandatory reporting laws exist on paper, but crumble in practice. Investigations compromised. Perpetrators walk free. This isn't isolated. It's a pattern, and families across Wyoming are living it. What sets this approach apart is that Representative Stiver actually listened. He's met with people who've experienced these failures firsthand, and he's heard them. The matters because House Bill 101 isn't some hollow gesture. It's a real mechanism to protect our most vulnerable citizens through meaningful in-person contact and accountability. Now, I won't pretend monthly visits work for every situation. Alternative contact methods are essential depending on circumstances. But here's what's not negotiable. Vulnerable adults deserve dignity. They deserve protection. They deserve consequences when rules are broken by bad actors. Being a guardian is genuinely difficult work, but it's also sacred work. House Bill 101 creates the guardrails to keep bad actors at bay and holds everyone accountable. There's much more to do. We're ready to work alongside you, other representatives, candidates, media, and families to dismantle these systemic failures and truly protect Wyoming's most vulnerable. Thank you, Mr. Chairman and committee, for your valuable time.
Thank you, and thank you for your, the explanation of your cases. It gives us continued to, it's tricky for us to, we just got to understand the spectrum of the issue, and this has been helpful for at least for us to understand this. I know Mr. Laycock has been very instrumental actually in pushing very hard for vulnerable adults in this process. And I know there's been a few laws that have come across in the last just couple of years. I'm a fairly new legislator, but it's an area we need to, and it's kind of interesting to see the combination of these two issues coming together here when you really look at the guardianship perspective merging with this older vulnerable adult issue. It takes a person like myself who might be a little bit less experienced in this space, and really you have to start to wrap your head around this problem a little broader. So thank you for that, and I really do appreciate it. I'm sorry for both of you for the pain and some of the issues, and I think there's a discussion maybe outside this committee meeting where we can talk about that, and I will be talking with Vice Chair Starivar on this topic as well to see where maybe we can look into this a little deeper. But that being said, committee questions for yeah, we've got just a few minutes. We need to resolve where we go with this bill. But if anybody has a quick question, fine, but it's got to be quick because we've got to move. We okay? You have a question, Representative Lean, please.
Thank you, Mr. Chairman. It's not so much a question. I just want to thank you for having the courage to come forward and speak about what's going on and the injustice served to your family. Thank you.
We are grateful. Sorry, you had a comment. Please try to keep it short, but thank you.
Yes. Hi, Kristen Taylor again. I have another concern we talked about was wording. And one of the growing concerns that we have is that the professional guardianship, they're changing guardianships to these individuals so frequently that they don't know their background history. They don't know everything about these individuals, and then they're making decisions for these individuals. One of the other things that has come up is that they send out an email to case managers and providers to give us all the information for their guardianship reports. So that means guardians commonly will ask for their medical summaries, behavioral updates, service participation details, incident documentation, budget information, and common engagement updates. And that is what they're using to fill out their incident reports. We also received an email about a month ago that they are lacking in guardians, and so we have to keep things very short. They're not always able to attend the meetings. It's very limited there as well. So it just raises up the concern of what they're charging for versus what the participants are getting.
Thank you so much.
Yes.
And please, we're kind of on the ropes here, so just a quick minute, please.
No worries. Victoria Snuck again, and I just wanted to add in that, as my colleague mentioned, that a lot of times they don't see guardians as they should until that 6-month time reporting period comes around, and then they're like, hey, we need all this information. We also have an individual that their guardian was changed, and we as a provider were not aware of this, did not know that their guardian had changed until we got the email for their 6-month meeting. And as the provider, this particular individual, we are responsible for their day-to-day. They live in one of our group homes. They get 24/7 care. And so it is very difficult to assure that they are getting the care that they need when we don't even know who we are supposed to be contacting. And one of our concerns as a provider is the monopoly that Wyoming Guardianship Corporation has in Laramie County and the state of Wyoming as the only professional. And when we get individuals coming to us asking for resources, we have nowhere to send them to other than Wyoming Guardianship Corporation.
And I think what I do at this point, I'm going to have to close public. Thank you so much, everyone, for coming. I appreciate it. Yes, ma'am.
We had to take my mother to the hospital about 2 weeks ago, and I called her guardian twice and sent 2 text messages and never received a response. By the time we got to the hospital, she decided that she wasn't that sick. She has a hiatal hernia and she has a heart murmur. So when she says she doesn't feel good and she's in pain, we address that situation. What would have happened if they had admitted her to the hospital and there was no guardian because I can't do anything for her?
Right. Right. Thank you so much. And thank you both for bringing the information. Well, really everyone. Thanks everyone for bringing this in. And I'm going to close public comment. We're right on the ropes for timing. Committee, what do you want where would you like to take this bill, Representative Lean?
Mr. Chairman, given the time constraint and the complexities of this legislation and the testimony that we heard, I don't feel that I have enough information to make an adequate vote on this to be able to properly protect our vulnerable adults, and I move to table the bill.
Do I need a second on a table or table second? Been seconded? All right. That is not a debatable motion.
Would you like a voice vote or a roll call vote? It's up to you.
Let's go ahead and roll. Go ahead.
I'd like one comment. If we do table this, we need to get it into the interim committees, judiciary and labor health.
All right. Let's go ahead and roll call this.
So roll call to table House Bill 101, Representative Brown,
Aye.
Representative Campbell,
Aye.
Representative Lean,
Aye.
Representative Lucas, Representative Riggins,
Aye.
Representative Storer, Vice Chair Stibar,
No.
Representative Worf, excused, and Chairman Locke.
Aye. I'm the same way. I feel that, so it has been voted to table. I want the people in here who are concerned about this to realize that we are not taking this as a light matter. For the people who have voiced their concerns and the folks who brought up some of the other issues, I think this is a very important matter. So we will be try to work very hard to get this into the proper committee in the interim to make sure these are listened to. So I would ask you all to please be attentive. In fact, maybe I'm going to torment my vice chair here, Stivar. I'm going to ask Vice Chair Stivar if he'll work this. We're going to try to get this into the interim so this can be worked hard so we can address these issues. We want to make sure we get the right level of guidance in there to protect people. At the same time, we don't want to have burdensome stuff that doesn't help anybody, right? And we want to make sure we get these processes and problems worked. I would probably say the Revenue Committee is not the most knowledgeable in this space. That being said, we'll work hard with the committee chair of the other committee to make sure we get this. We'll try to do our best to get this in there and get this heard. I will do my best to jump in on that as well. And we really appreciate everyone taking your time to educate us and bring this important issue up. I really do consider it a very important issue. I do not want to minimize the fact that we've tabled this. We have not done this lightly. I do want you to understand that very well. So I do think there's some other issues that probably need to be addressed outside of this committee, and those of you who have raised those issues, I'll be talking with Representative Stivar, and we'll see what we can do to get people additional help where we can. But for all of you who came, I'm very grateful for what you guys have done here and what we're working, and we'll see if we can't keep this moving. And let's get it done right in the interim, so when this comes to the committee or comes to the legislature next year, it's a good bill and we get something moving. Thank you so much. Everyone have a blessed day.